Welcome to Spectacular Chicago. My name is Jim Balser. Tonight I'll be your host. This evening we'll discuss the network news media, and it relates to our democracy is being undermined by the governor of the state of Illinois. Governor Pritzker donated $1 million to two judicial candidates for Illinois Supreme Court, Justice O'Brien and Justice Rochford. In doing so, he violated the canons of ethics on those judges by giving them money when cases before the Illinois Supreme Court were likely to result in those judges hearing Governor Pritzker's Safety Act that relates to the no cash bond and the assault weapons ban. We've all heard about that, but let's talk about how that impacts our rights. When Governor Pritzker donated that money, he knew the position of those judges. He didn't give them $1 million each because they were going to vote against him when these cases came before the Illinois Supreme Court. Everybody knew that the Safety Act and the assault weapons ban was going to come before the Illinois Supreme Court. When it did, however, motions for recusal of that Justice Rochford and O'Brien were filed and presented. They, in their infinite wisdom, didn't think that $1 million was a conflict. Now let me say this. If you or I were before a judge and we gave that judge $1 million, first, that judge would have been under an ethics oath to recuse themselves. But the Illinois Supreme Court doesn't see it that way. Instead, they denied the recusal motions of counsel. We hold our constitutional rights dear as what a child, a dead puppy, and speaks to it as though it were alive. Governor Pritzker undermined our democracy. In the news, we're hearing about, threats from without, meaning across the world, relates to Israel and Ukraine. We have bigger threats here in our United States. In fact, in Illinois, we have a governor that thinks he can undermine democracy. He can circuit the process for his own political gain. One thing I should say, Governor Pritzker calls himself J.B. Pritzker. That's a lie. His name is J. Robert Pritzker. But okay, I'll go with J.B., and I'm going to add a few vowels. Jabba. Jabba doesn't seem to think that he has to follow the rules. And another thing I've noticed, and many of you don't know or maybe aren't aware, there is not a political question that does not become a judicial one. We see it at our U.S. Supreme Court level. We see the protests. We see the backdoor dealing. The politicians want to control the judiciary. The judiciary makes rulings on their issues, and they want to make sure that it falls on the right side of the case. So when judges are co-opted and the system is co-opted, we lose our democracy. You look at countries that lost their democracy. The first step to taking democracy is taking the guns. You look at Venezuela, you look at Australia, you look at all these countries that one time had thriving democracies, and what did they do when the socialists got in? They took the guns. Now listen, I may or may not be against an assault weapons ban, but they didn't follow the process. It's a slippery slope. They take those away, what's next? We have over 15,000 refugees from Venezuela. 8 million people out of 30 million plus have left Venezuela. Why is that? Because the socialists took over, took their guns, and then the public, when their democracy has been undermined and they're threatened and they're starved because they won't vote a certain way, has no choice but to leave, and they can't fight back for their democracy because their guns are gone. They've been taken away. Now, one thing I would like to add on the assault weapons ban, all those folks who legally bought those guns were required to register those weapons with, I don't know, the Illinois State Police. On information, only 1% of them have done so. I'd like to know where they got the information on the 1%. We'll see where that goes, but I suspect that none of those assault weapons ban owners are going to sit there and register their weapons, so we'll see where that goes. Now, we have a judicial inquiry board in the state of Illinois that was placed by the Illinois Revised Constitution of 1970. The Judicial Inquiry Board is charged with the responsibility of investigating complaints of judges in the state of Illinois. In fact, it was put in place because Illinois Supreme Court justices in the late 60s were taking bribes and kickbacks relating to some racetrack. I don't think it was Arlington Park, but it was another one. And they ended up getting put out, and somebody said, you know what, we've had enough. There's nothing in place to watch over these folks in the judiciary. So the Judicial Inquiry Board is one where an ordinary citizen can go, or anybody else that has information on violations of the judicial canons of ethics, to report that misconduct. I have received a copy of complaints, when I say complaints, plural, against Justices Sheila O'Brien and Elizabeth Rochford of the Illinois Supreme Court. The Judicial Inquiry Board elected not to do anything. Why do you think that is? Well, pursuant to the Illinois Constitution, Article 6, the governor of the state of Illinois makes 5 appointments to the Judicial Inquiry Board, including some members of the public. The Illinois Supreme Court on Information makes 2 appointments. So you have the governor who has conflicting interests in this matter. You have justices that have an inherent conflict of interest by taking the $1 million each. They're not recusing themselves. And then when a citizen wants to file a complaint with the Judicial Inquiry Board, they've been co-opted. They've been deprived of their rights, their due process, and everything else that we hold near and dear. The Judicial Inquiry Board has done so on numerous occasions relating to the Illinois Supreme Court. So I'm going to segue a little bit into the illustrious Senator Durbin, who chairs the Senate Judiciary Committee in Washington, D.C. Now, we all know that the Democrat Party, the symbol is the donkey, or commonly called a jackass. So, while all these antics are going on with our Illinois Supreme Court, while our constitutional rights are being subverted by unethical political and judicial actors, Senator Durbin is braying like a jackass in Washington on Capitol Hill about Justice Thomas of the U.S. Supreme Court accepting hospitality from wealthy friends. Now, I'll say this. I don't know what I don't know about it, but when you're in that position, you can't just sit there and go out to a restaurant. You can't walk the street. You got security around you 24/7. There's only a few places you can go, and sometimes you have to hang out with wealthy people that, you know, can give you a sense of security in their residences or premises, or maybe they've got an island someplace, whatever the case may be. But while all that's going on here in Illinois, he has the gall to sit there and talk about Justice Thomas of the U.S. Supreme Court, and he has nothing to say about these judges here in our own home state of Illinois taking $1 million and hearing cases that undermine our democracy. The Second Amendment is it's an element of our democracy. It keeps the government honest. I'm not a gun owner. I've never fired a gun, but I understand the significance, and if anybody chooses or desires, you read what the Second Amendment was put in place for. Now, if we could put on screen Justice Rochford and Justice O'Brien with Pritzker again. Okay, so I'd like to add, relating to the Judicial Inquiry Board, that Governor Pritzker holds sway over their budget. He can decide to cut their budget. I think Governor Rauner was attempting to do that as well at one time, cut their budget, they couldn't do their job, and because they're beholden to the governor, they do something that the governor doesn't like, their appointments can be, I don't know if they're guaranteed, but they won't be reappointed, or they maybe don't ever find another government job. The fact is that to sit there and ask the Judicial Inquiry Board to investigate the Illinois Supreme Court would be akin to beseeching the whores to shut down the whorehouse, because it's the same entity. In fact, J. Robert Pritzker is a lawyer. I don't know if many of you knew that. I don't find anything anywhere where he's been turned into the ARDC, or commonly known as the Attorney Registration and Disciplinary Commission. Every lawyer that became aware of this ethics violation by Pritzker, giving the $1 million in his cases, they were, by virtue of their law license, required to turn in Pritzker. I don't think any of them did. Every judge that came across this case, by virtue of their station as a judge, was required to turn this in. These Illinois Supreme Court justices, by virtue of their position, were required to turn this in to the Judicial Inquiry Board and the ARDC. None of them did. We can't trust them, and they're undermining our democracy. Now, I want to discuss a little bit the illustrious Kwame Raoul. I can't even spell the name, and I'm going to talk a little bit about why I believe he got the gig. Such an unusual name, hard to spell, it's difficult to be elected, except somebody wanted him in office. Here is my theory. Some years ago, in the Illinois Supreme Court, the Chief Justice of the Illinois Supreme Court, Robert Thomas, filed a defamation case against a small community newspaper, and in doing so, managed to upend the court system from top to bottom to extract the largest defamation award in Illinois history over an opinion column against this small community newspaper with a circulation of 16,000. Now, all the attorneys that were managing the case, both defending it, prosecuting it, were required by virtue of their law license to turn these justices in. Nobody did it. Now, I did it, and the Judicial Inquiry Board never acknowledged my letter, even though I have a receipt for it. They never responded to me. They decided that because they were the Illinois Supreme Court, meaning their appointment, their board members, all this thing, they weren't going to do squat. In fact, they did do nothing about it. I had to file a FOIA request to the Judicial Inquiry Board. Now, what is a FOIA? It's a Freedom of Information Act that allows a private citizen to request of a public body documents. So public bodies, you know, there's many, your municipal public bodies, your state, certain state offices are subject to FOIA. I asked the Judicial Inquiry Board, what is the outcome? What is the status? What did you do? Instead of responding to me, they did nothing. I filed an appeal with the Illinois Attorney General's office. That's the public access counselor. That was put in place to hear appeals for the public. Somebody figured out that when a public individual, private individual, filed a FOIA request seeking public information, and that public body decided, yeah, we're going to ignore it, we're not going to do anything about it. Happily, they enacted laws that said, okay, we're going to have a review, free review of a FOIA request denial. And that was called the Public Access Counselor, which was the Illinois Attorney General's office. Surrounding the time of my FOIA request of the Judicial Inquiry Board and then the subsequent appeal, Kwame Raoul, could it be, when he was a state senator, elected to float a bill. And I'm going to read, it says, 95th General Assembly, State of Illinois, 2013 and 24, SB 2222. And synopsis is introduced 2/15/2013 by Senator Kwame Raoul. Mr. Raoul, and I'll read the pertinent part, the Judicial Inquiry Board and the judges are part of Article 6 of the Illinois Constitution. And he seeks that public body in this bill does not include a child death, I'm going to read the whole sentence here so it's not out of context, include a child death review team or the Illinois Child Death Review Team's Executive Council established under the Child Death Review Team Act, or any entity created pursuant to Article 6 of the Illinois Constitution. Now, Article 6 of the Constitution is the Judicial Inquiry Board in pertinent part. He does, all the text in this bill, except for these words, or any entity created pursuant to Article 6 of the Illinois Constitution, is just plain text, except that one is underlined relating to Article 6. So he's trying to sneak this in. Damned if you're going to let your pants fall down. But the timing of it is highly suspect. Just prior to this coming out, I had filed my appeal with the Illinois Attorney General's office under the illustrious, what's her name? Lisa Madigan, who is apparently related to, I guess her father is managing a case of his own now in court. They determined that the Judicial Inquiry Board was part of the judiciary, even though they're not. They're not judges. They're an investigatory body, and investigations that have been completed by investigatory bodies in the state of Illinois are subject to FOIA. Now, I'll fast forward a little bit on that. When I reached out to the Judicial Inquiry Board on another matter, which I'll get into a little later in the show, and I said, well, since you guys are part of the judiciary, you're entitled to use emails and other things. They don't like to use emails. They don't want any record of a citizen making an inquiry where they can be tagged with not doing anything, which has been their modus operandi. I talked to somebody there recently. I said, well, you're now part of the judiciary. Well, no, we're not. Well, now that another bill is being floated to subject the judiciary in the state of Illinois to the Freedom of Information Act requirement, they are no longer part of the judiciary. So they were part of the judiciary when it was convenient to say they were part of the judiciary. Now that a bill is being floated to make them subject to FOIA as being part of the judiciary, they're no longer part of the judiciary. That's how things work in Illinois. You just kind of never know who you're dealing with. So on to the next topic. I'd like to put on screen a frame of Governor Pritzker in all his glory. Now, why am I showing you this design element? Well, as you can see, this is a Kohler toilet seat. I've elected to frame Governor Pritzker. The illustrious Governor Pritzker, even for a billionaire, to save $300,000, removed all the toilets from one of his Gold Coast mansions, and therefore was able to reduce his taxes by $300,000. Pretty good savings. Now, what does this mean? I'll tell you what it means. We've got to unseat this man. Come next election, we've got to unseat him. Jabba, as I call Mr. Pritzker, make no mistake, everybody that I talk to thinks he's going to run for president of the United States in 2028. He just has the cabal to do it. I'm telling you all, if you don't pay attention, he'll run. I don't want to see him get to the White House. I don't want to see him get past the outhouse. But you all have to do your part and make sure that this man doesn't get out of the state of Illinois or out of the federal, anything federal. I don't care if it's Senate or president for that matter. Now, where are we at here? I have pending a lawsuit against our illustrious Metra. They're the transportation entity that serves primarily the suburbs. The lawsuit deals with FOIA, Freedom of Information Act request. Now, one request I made to them that they never responded to deals with a FOIA that I presented relating to Phil Pagano, the former chairman of Metra, if you can on-screen that. Phil Pagano stole over $500,000 and misappropriated $500,000, you call it what you will, from Metra while serving as chairman. A corporate kleptocracy unparalleled at the agency. And my FOIA request was, okay, let's have a copy of the board minutes, let's have documents relating to that theft of $500,000. Now here's an interesting factoid. When Mr. Pagano was, the board had impaneled a meeting to remove him over this conduct. Before the board could convene, Mr. Pagano threw himself in front of a Metra train committing suicide. Well, how does everybody know he committed suicide? Well, I'll tell you how. Normally, he would know not to stay on the train tracks when an oncoming train is approaching, but in his pocket was a note, which is standard issue to Metra employees, what to do in case of a train striking a pedestrian. He had it in his pocket conveniently so anybody that found it would know what to do. Now, I would say he lost his train of thought. Now, Metra didn't think they had to respond to that FOIA. Now, the one that I have a lawsuit against Metra on relates to a simple vendor contract. I had the name of the contract. I requested it. They decided they weren't going to give it to me. Now, as a public body, they were statutorily required to do so. Anybody that files a FOIA against a public body, that might be the police department, the mayor's office, anybody that is subject to FOIA, and they don't respond to a non-commercial request, so you're a private individual, you're not a company using it for commerce, they have 5 days. If they don't do it within 5 business days, they are statutorily required, upon filing a lawsuit, to pay you between $2,500 and $5,000. That's a statutory, mandatory civil penalty. And if you have a lawyer, they have to pay those attorney's fees. So I'll tell you this, the attorney's fees to date on this lawsuit I have against Metra over failing to provide me a simple contract that they had the number, is north of $100,000. They don't want to take their medicine. But an interesting thing happened during the proceedings. So I have counsel managing this case for me. I also filed an additional appearance in the case because I had a suspicion, a strong suspicion, and then I confirmed that the judge in my case, Judge Carolyn Kate Moreland, if we can on-screen Miss Moreland, her law clerk was personal friends with one of the attorneys handling the case for Metra. Now, how do they know that? There were 2 attorneys. I wasn't sure which one, and I attempted over time to get that information from Metra by filing another FOIA. Now, the Freedom of Information Act request on that was their employment histories on these 2 attorneys to determine which one of them, by virtue of their resume, what college they went to, I could tie it into the judge's law clerk. So what does Metra do? Unrelated to this FOIA case, yet they file within the case a motion for protective order to prevent me from getting and obtaining those documents. So Judge Moreland's law clerk, his name's Harry, and I said to Harry, hey, Harry, you know one of these attorneys real well. They were carrying on such that I thought, you know, heck, I thought they were going to retire to the anteroom at any point. My spider sense was tingling, but I couldn't say which attorney it was. You can't sit there and file a motion for substitution of judge for cause, which is what I did, unless you know who. You can't sit there and say, oh, well, I think it's one of them, and you look like an idiot and you're going to be sanctioned if you try to do that. But I finally, after 2.5 years, ascertained which lawyer it was. In fact, that lawyer is no longer with Metra. I objected to her being off the case, but the Judge Moreland, wanted her off the case, I suppose, because of that conflict. And they were hoping to couch the issue, but I wasn't going to let it go. So the substitution of judge for cause against Judge Carolyn Kate Moreland was filed to get to the bottom of it. During those proceedings, when you file a substitution of judge for cause, they're not very common. You have one for cause and you have one of right. And as of right, you have to do it before the judge has made any substantive rulings in the case. For cause, typically you can do it at any time, but you have to do it at the earliest possible opportunity when you discover, you know, the conflict. So substitution of judge as of right was no longer practical in this case. But for cause, it was certainly justified. Now, It went to Judge Thaddeus Wilson. If we can put Mr. Wilson's mug online. Judge Thaddeus Wilson, in addition to Judge Moreland at one time, was an Illinois Supreme Court appointment. The Illinois Supreme Court likes to control who is on Chancery Court, because that's the court that's making all the important decisions within Cook County. Now, I'm happy to see an African American on the bench. DuPage County, there are no African Americans, there's no Latinos on the bench, and in Chicago we have good diversity. However, I'm going to say something. Mr. Thaddeus Wilson writes this 8-page opinion, which I'll describe as pure, unadulterated drivel. Usually you have learned men on the bench, and I've seen enough and I've studied enough, and I don't categorize him as such, but I think he tries to do his best. Mr. Wilson, Thaddeus, opined that since I waited 2.5 years, but he didn't listen or read the substitution of judge for cause. As I stated earlier, the judge, Judge Moreland, her clerk, counsel for Metra, despite the fact that I'm sounding the alarm, hid it. They hid it. They didn't disclose, and I'm trying to uncover it, and then they're filing a motion, protective order, to prevent me from getting to the bottom of it. And then Thaddeus Wilson has the balls to sit there and tell me that I waited 2.5 years when I'm sitting there for 2.5 years trying to figure out which of the attorneys was personal friends. So Metra finally admitted during the hearing, and Thaddeus Wilson, well, I'm going to take that under advisement. What advisement? They admitted it, but he looked for a way not to interpret it from a liberal construction and granting it, decided to deny it. He was going to deny it. That was my sense all along of this man. Frankly, I don't trust him. In fact, an analogy. So the same judge is handling the case who had the conflict in her law clerk. The law clerk controls the judge's docket, makes opinions, writes the opinions, rulings, does a lot of things that the judges do. The judge is mostly a figurehead, but they usually have law clerks that draft the briefs and do other things relating to the case, or the opinions, not the briefs. So I would not buy a used car from Judge Thaddeus Wilson, because here's what he would do. You've all owned a contemporary car, you got a check engine light, right? Check engine light means there's a diagnostic code, there's some problem with the car. You can reset that code on the car, disconnect the battery for a while, disconnect, and the code will go away, but it'll eventually, the code will come back in after a few sequences. So that's all Judge Thaddeus Wilson did. He just disconnected the battery from the car, connected it, reconnected it. Viola, the trouble code is gone, except in this case, I'm back to the same judge whose clerk was personal friends with the attorney for Metra. And Metra thinks it's a joke. I don't even think their board members are aware of what's going on. But, you know, in view of their gross ineptitude and dishonesty in these proceedings, you know, maybe they should be absorbed by another agency and put out of their misery. Now, I would get into another case that was brought to my attention, and I thank the people for bringing it to me. I'm gonna, let me find the paperwork. This was a very nice couple, and I met them personally, and I talked to them about their situation. And I have a copy of the court pleadings that they filed. It was Andreas Vassilos versus Joseph S. Scaduto. and it's under calendar 5, which is Judge Cohen, and the case number is 2023 CH 07992. Now, the substance of this, they were seeking, this is a verified petition for ex parte, temporary restraining order, and permanent injunction. Now, you might ask why somebody would file that and why I have it, and I'm looking at it. And it's here today because it was such egregious conduct complained of that the defendant engaged in. So Mr. Vassilos, the plaintiff, owns an apartment building. And he was informed that somebody had broken in the back door of his 3-story apartment building. Well, the tenants he's got very good tenants. He takes good care of them, maintains the building, just a great guy. And then the tenants say, you know, the door's broken in. Also, we're hearing strange noises from the 3rd floor. There's water coming in, there's noise, there's all kinds of stuff going on. So his partner, or his girlfriend, name is Blanche Black. Now, if anybody remembers MTV from the early 80s, Blanche Black was a very popular singer. I'll let you Google her name. It's Blanche with an E and Black with an E at the end. And Mr. Vassilos has affidavits here pertaining to his building. Now, here's what they discovered. And she states, on or about August 26, 23, I was on the 3rd floor porch with Andreas. Andreas said to Scaduto, that's the defendant, "You've got to get out of here. Time to go." Then the man bursts out of his, not his, but the 3rd floor apartment. He's got no clothes on. And he's holding a pipe wrench in his hand. And he's yelling, and this is verbatim from the court pleadings. He's yelling loudly with a crazed look on his face. "Back off, bitch. Get the fuck out of here. I'm going to fuck you up. You're going down the stairs." Now, there are 3 affidavits in this petition before Judge Cohen. If we can put Judge Cohen on screen for a second. There's Judge Cohen. Geez, he'd get a wig, he could do Howard Stern. So Judge Cohen has a deserved reputation of being overly vigorous with parties in his case. If you don't understand him, he lacks judicial temperament. And I'm going to share with you some comments that were made by Blanche Black, relating to Judge Cohen. And I'm taking these verbatim off my thing. Here's what Judge Cohen said to the plaintiffs that were in fear of their life and had been threatened with great bodily physical harm. "Where is the complaint?" Well, Judge Cohen, I have the complaint right here. I'm reading it. Apparently you didn't. And then he said, "This is not a complaint." Yes, it is, and it's verified, sir. "Also, why should I hear only one side of this?" he says. "Where is your evidence? I can't go on your say-so alone. I think he is right according to the law." I don't know who the heck he's referring to in relation to the law, because the defendant hadn't appeared. And then she says, "I felt very intimidated and ungrounded in front of him." Now, these people are being threatened with great bodily harm, and Judge Cohen is shoving it up their ass. He has no business. He lacks judicial temperament. He has no business serving as a judge, let alone in chancery in that courthouse. Probably he would have been satisfied with evidence that they were on the 10 o'clock news and had been killed or thrown down the stairs, as this man stated. And then the other thing in this complaint that they had filed, he's trying to extort them. He says, I'll be out by tomorrow for $5,000. I'll be out in a week for $2,500. Affidavits from other tenants in the building are attached to this motion, everything else. And Judge Cohen failed to acknowledge that they were speaking and they could have been killed. This man has no business on the bench. At this moment, I located a vintage video, which some of you may remember. I remember it, and that's why I'm putting it on screen. Clint Eastwood, Dirty Harry. We can put on screen Clint Eastwood. He has a few things to say to the good Judge Cohen.
Callahan. Sir? I don't want any more trouble like you had last year in the Fillmore district. Understand? That's my policy.
Yeah, well, when an adult male is chasing a female with intent to commit rape, I shoot the bastard. That's my policy.
Intent? How did you establish that?
Well, a naked man is chasing a woman through an alley with a butcher knife and a heart on. I figure he isn't out collecting for the Red Cross.
I think he's got a point.
He's got a point. Now, another matter that was brought to my attention is a case entitled Midland Funding LLC versus Diana Alvarez. Now, Diana Alvarez is a single mom who was being sued for some perceived debt on behalf of the plaintiff. However, and if we could put Judge Marie Eileen Dempsey on screen. So, what happens is in most civil proceedings, when a lawsuit is filed, a summons is issued and the complaint is filed, and that summons is served by either the sheriff or a special process server. There are rules relating to service of summons. As example, if anybody has been in that situation, the sheriff or the special process server, you can go off screen, is required to serve somebody over the age of 13. That didn't happen in this case. The process server served Miss Alvarez's 11-year-old. Now, in the affidavit of service by the special process server, he submits the affidavit of service saying he served a 39-year-old male. Well, Diana Alvarez doesn't have any 39-year-old male living with her. She has an 11-year-old living with her. Here's the rub. The 11-year-old, at the time, is 6 feet tall. I mean, he's right out of Guinness Book of World Records, and he's currently age 14, 15. I saw his picture. He's 6'6". Big kid. I worry he's going to be 10 feet tall if he doesn't get looked at soon. She files a motion before Judge Marie Eileen Dempsey to vacate the order as void. Now, what does that mean? In layman's terms, service of summons is jurisdictional. They have to follow it to the letter of the law. An 11-year-old got served. Process server looks at this, okay, this can't be an 11-year-old, it can't be, it's got to be, he writes 39 years old. So this woman files a motion to vacate it because it's a void order. You can attack a void order directly or collaterally at any time. A void order today, it's void in 5 or 10, 15, 20 years, you can attack it. Service of summons. If they don't perfect that service, you don't have a case. You have to start over, or you can't refile it if you've blown the statute of limitations. Now, what does Judge Dempsey do? She wants to talk to the kid. Now, the kid is in school. He's going to take off school for court. You don't have kids testify in court. And as I read her motion to vacate this, it was spot on. Law, everything. I don't know who drafted it. They did an excellent job. She did it pro se. However, she's arrayed against one of the largest bill collection firms probably in the state of Illinois, Blitt and Gaines. And Blitt and Gaines, you know, I didn't have time to investigate how much money they're donating to whose campaigns, but one unspoken truth, an unfortunate truth, is the fact that when judges run for retention, re-election, election, it depends upon their circumstance. You and I don't donate to judicial campaigns. Who do you think contributes to the judicial campaigns? The lawyers. The lawyers do that. So I wasn't able to immediately tie in with this judge, but the fact is this law firm has a lot of resources, a lot of people, and I believe, I'm stating a belief, that you know, because of their volume and their presence, they sometimes get things that they shouldn't get or didn't deserve. So this lawyer writes this, there's no command of this is a crap response. Now, a fine point, it's the petition is verified to vacate. She's not required to verify it, but the other side has to verify their response, and they didn't do that. Should have been granted, except Judge Dempsey, let's be fair, like a neutered dog, she just didn't get it. Well, there's a motion for reconsideration, and I'll be watching it. In my next show, I'll report back further. Now, there's another case with a DuPage County judge I'd like to talk about. And if we can put on, we're going to skip here from 11. We're going to go right to, let's see here, Judge Linda Davenport, if we can. That's the short-haired, looks like a dowdy real estate agent. Thank you. Judge Linda Davenport was recently appointed by the Illinois Supreme Court from DuPage County to the 3rd District Appellate Court. Now that's a state position, the other's a county. How did she get that position? But here's what she did before she took the position. I have a copy of a substitution of judge that was filed against Linda Davenport. Now, when a substitution of judge is filed, that judge loses all power and authority to do anything on the case, except to send it to the presiding judge in the division for reassignment for hearing. In other words, the judge can't hear their own substitution of judge. In pertinent part, the judge was being substituted for cause because she, according to the pleadings, had accepted campaign contributions from the attorney that was the opposing attorney. So this female attorney representing the wife in a domestic matter is making that assertion and articulating it with documents provided by the election commissions, which keeps that information. She also talks about, in that substitution, that the wife had retained her. The mother paid the retainer. It's the mother's money. Keep your eye on the ball. The mother retains. Judge Davenport says, well, counsel, I'm going to have you disgorge, meaning give part of that money to the husband's lawyer, the one that, you know, maybe he'll give it back to her for a next election cycle. She did that. It's the mother's money. It's not the client's money. Okay? She wasn't entitled to do that. She did it. I took a look at Linda Davenport's background online. Google Linda Davenport, and you're going to find, I mean, I've never seen so many complaints against anybody else, but there's another, and no command of the English language will allow me to properly express my sentiments. She is shit. So what does she do? Instead of transferring the case to the presiding judge for reassignment, she directs the DuPage County Sheriff, who serves as courtroom security at the DuPage County Courthouse, to cuff and shackle counsel, place her in the witness box, that's next to the judge, to compel and coerce an apology. And if she doesn't do so, what happens? You're going to spend 72 hours in jail. I read the transcript. I'm not just taking anybody's word for this. I read it. The sheriff did that. Davenport directed it. She had no jurisdiction to do any of that. In fact, that attorney should probably properly file a federal lawsuit against the bitch. Linda Davenport, during the discussion, is gloating about the fact that she has been appointed to the 3rd District Appellate Court, and she mentions, I guess it's, oh, could it be Illinois Supreme Court Justice O'Brien? Remember her? She took the $1 million from. So as I look at Linda Davenport, she has a propensity to manage large sums of money for judicial campaigns, Bonnie Wheaton and others. You might remember DuPage County a little bit. Rolando Cruz, you know, they railroaded Hispanic to a murder conviction he didn't commit. He spent time on death row, and they were all trying to get him executed. Marcus Lyons, African-American, railroaded to a rape conviction he didn't commit. Well, those two judges, they had Judge Burkett, or not Judge Burkett, excuse me, State's Attorney Burkett and Assistant State's Attorney Creswell. Creswell is appointed to become Chief Judge of DuPage County. Imagine that. You can railroad somebody to a rape conviction, and they make you Chief Judge in DuPage, okay? Burkett is elevated to the 2nd District Appellate Court by Robert Thomas. That's the same justice who manipulated the system he dominated from top to bottom to extract the largest defamation and award in Illinois history over an opinion column against a small community newspaper. Okay? One thing I'd like to say, this isn't just the Republicans or Democrats. They're both doing it. And an analogy came to me in the dog park this morning. I saw 2 dogs stuck together. So if you can picture in your mind's eye, you have the Republicans on the one side, Democrats on the other. They're stuck together like copulating dogs. One can't move without the other, each hating the other, but joined together in dissolute enterprise. Now, I have one last thing to talk about, and that's going to be relating to a little bit about Judge Moreland. A Chicago Tribune article was prepared that talks about an electronic eavesdrop that was placed on Alderman Burke. And Alderman Burke, and he says we, apparently, he states, this is an excerpt from the Chicago Tribune article, and this is a federal eavesdrop on Alderman Burke, which he fought tooth and nail to suppress, but the federal court judge here in Chicago released it. It says, during the conversation, which Solis recorded with a hidden wire, Skidall voiced concern about potential issues with Amtrak as the project moved forward. But Burke put his mind at ease, saying he was close personal friends with an Amtrak board member whose daughter Burke had helped become a Cook County judge. And I'll read what he says here. One of the members of Amtrak is a guy by the name of Jeff Moreland. Burke said, according to, let's see, Dow's ruling, he's a presidential appointee to the Amtrak board. We made his daughter a judge here in Cook County, and I know if you ever run into a problem, Jeff can be helpful. Now, what does that pretend? Now, Judge Moreland is the judge handling my case relating to a railroad, and I take issue with it. I don't want to run my case. I don't want her to rule for me. I don't want her to rule against me. She's put in place by corrupt actors. Now, one thing to mention, Burke uses the word we. Now, he didn't put her on the bench. His wife did. I think it's Ann Burke. She was former chief of the Illinois Supreme Court. The apples don't fall far from the tree in Illinois courts. Now, I thank you all for listening. I welcome your input, your comments, your opinions. Again, without a strong judiciary, we lose our democracy. We must have an impartial democracy. If you look at the issues that confront our society, you have the judiciary, you have the state's attorneys, and you have the police. The police aren't the problem. The prosecutors aren't the problem. It's the judiciary that's undermining our democracy. I'll have more to come, but for right now, I'll wish you all good night and look forward to your comments and questions. You can address to me at the email provided at the end of the show. Thank you.